hello YouTube, and welcome. I am your host, Americles. Today, or yesterday, to be more accurate, was a great day because yesterday, a federal judge on Betsy DeVos and her Department of Education and basically said that it is illegal for her to keep postponing the rule for defense to repayment, which was an Obama-era program set to take effect in 2017, said it's illegal for her administration to keep delaying this rule's implementation. So therefore, there is a very strong possibility that the Department of Education will finally start going through the 100,000 application backlog and issue rulings on students who feel they've been defrauded. But hold up a sec, let's roll it back, let's walk it back a bit. For those of you who are not aware, what is DTR, or Defense to Repayment, and what's going on with it? So basically, Defense to Repayment is a program offered by the US government, or more specifically the Department of Education, which protects students from predatory recruitment practices by colleges and also fraudulent pretenses for you having signed up for college. Let me give you an example. So if you sign up for college because the college in question gave you job statistics that said, oh yeah, if you go to this college, you get this degree, 90% of our students go to work in field within 6 months and they make X amount of dollars. And then you look at those numbers and you say, oh, you know what, that sounds pretty good actually. And you go to the school and you go through the degree program, and then by the time you graduate, you come to find out that, damn, you can't find a job in the industry, like not even close. And what's coming to light more and more is that these schools have in fact made up these numbers. Totally phony. They were designed to get you to sign up. Numbers were entirely made up. And so what sort of recourse do you have? Well, now, thanks to DTR, you do have some recourse. If you can prove that the school provided you with fraudulent job statistics which caused you to sign up for school to begin with, then you can submit your defense to repayment application, and with any luck, the government will then discharge all your federal student loans, or at least part of them, and they will also reimburse you on any payments you might have made on those federal student loans. There's also other rules in there that if you can prove that they were predatory in recruiting you. So for example, if you can prove through, say, an email chain that they have harassed you day and night after you met with them only once and expressed a lukewarm interest, but then they wound up calling you and emailing you and basically using cruel psychology tricks on a naive 18-year-old in order to get you to sign up, that's predatory, and that is also grounds for you to file a defense to repayment form. So now let's jump forward again a bit and examine why Betsy was delaying the rule to go into effect in the first place. Now, the general consensus in the public is that it's because she is an evil witch who hates poor people and she wants to yeet on all of them with her 7 yachts. But there might be other reasons, and I like to give people a benefit of the doubt, so let's explore this a little bit. So I've read an article about this, and in it, DeVos makes a statement. She says her first priority is to protect students, but that last year's rulemaking efforts missed an opportunity to get it right, and quote, the result is a muddled process that's unfair to students and schools and puts taxpayers on the hook for significant costs. So it's really kind of a very vague statement, and I want to say that here she's just playing to her conservative constituents because conservatives are technically in power now, so perhaps she wants to make it clear to her constituents that, hey, yeah, I'm against the expansion of government and I don't believe in government handouts just like you guys do. So, yeah, we're gonna delay this rule and things will be great. Perhaps that's the reason. Of course, it's not like it's without precedent that the government has bailed out a private institution for mucking up the situation for the public at large. You might have heard about the recession and how we used hundreds of billions of taxpayer dollars to bail out companies, and the companies then gave their CEOs golden parachutes. This happened, and it has precedence, so except in that case, I want to postulate that companies approached politicians and said, "Oh, look, we're melting down, but if you give us those sweet taxpayer dollars as bailouts, perhaps we will donate to a certain foundation. Someone's re-election campaign is coming up. Perhaps we can slip a few bucks towards that." So there was incentive created by companies. This time, there is no incentive. The incentive is to protect poor people, and poor people can't buy Betsy an 8th yacht, so it's useless. There's absolutely no point at all. So who knows? Point is, she wanted to rewrite the rules, and something tells me it wouldn't exactly be favorable to the consumers, especially considering that private institutions, for-profit colleges, really hate the whole program that DTR is based on, so it might have something to do with that. Perhaps they're slipping DeVos a few buckaroos here and there to rescind these protection rules. Now I want to briefly dive into the court document that was posted is a United States District Court for the District of Columbia. So there are two plaintiffs here, Megan Bauer and Stefano Del Rose, versus Elizabeth DeVos, or Betsy DeVos, and this is a summary judgment. The judge is ordering for something to happen. Let me briefly read through the introduction. I'm going to skip the whole statement of facts because it's very long, but it's also a fascinating read. I encourage you to read it. So, introduction and summary of argument. The need to protect student borrowers from predatory for-profit educational institutions has become ever more apparent over the past several years, as investigations have revealed fraud and misrepresentation that have lured students into amassing significant student loan debt under federal government programs in exchange for low-quality and often useless educations. These predatory institutions stand on precarious financial grounds and close at alarming rates, stranding students and leaving federal taxpayers with the bill. Plaintiffs Megan Bauer and Stefano Del Rose are two of the tens of thousands of student borrowers nationwide who have been harmed by the practices of these predatory institutions and continue to be harmed today. In 2015, the Department of Education began a negotiated rulemaking process as required by the Higher Education Act to examine proposals to address these programs, such as by making sure students have more complete information about schools before they enroll, minimizing the risk that federal financial aid dollars go to financially unstable institutions, and helping students who are victims of predatory institutions to obtain relief. When the negotiated rulemaking did not yield consensus, the Department of Education went through a full notice and comment rulemaking process, considering over 10,000 comments before publishing a 150-page final rule, known as the Borrower Defense Rule, on November 1st, 2016, with an effective date of July 1st, 2017. I'm going to skip a little bit over here. The department has vastly exceeded its authority under Section 705. Section 705 authorizes agencies and courts to delay a rule's effective date because judicial proceedings are pending when justice, quote-unquote, so requires, and for no other reason. The Department of Education did not even acknowledge the standard. Instead, it engaged in a cursory one-page discussion that failed to acknowledge any negative impacts of a delay on students, the public, and the government itself, including the harms that the agency itself had determined only months earlier that the Borrower Defense Rule would help prevent. So they're basically saying, Department of Education, you're contradicting yourself, and you are violating the rules. The document then continues with a very spicy statement of facts, and I'm going to skip over that because it's very lengthy, but it is interesting nonetheless. And I'm going to finish with the conclusion of this document. It says, for the foregoing reasons, the plaintiff's motion for summary judgment should be granted and the delay rule vacated. And finally, tomorrow, September 14th, 2018 at 10:30 a.m., the judge will determine how to proceed with the case following a hearing. So we'll hear more about this, and we'll also find out perhaps in what time frame the judge expects the Department of Education to review the backlog of 100,000 applications. So yeah, all in all, great news for anyone who has either filed a DTR or is thinking of filing a DTR. Now there's a bit of certainty floating about that they might get reviewed. Now, as for whether the Department of Education will fairly assess these applications, that's a whole different story. But we'll see what happens. At least the courts are on our side. So with that, I'm signing off. Thank you for watching, and if you enjoyed the video, please like, subscribe, and hit the bell button or else it doesn't count.